Okay, and we'll reconvene, and we now head to our final witness in this program. So, Amy, in your hands, welcome. And if you'd like to give us a brief overview and other matters that you want to respond to before we go to questions. Thank you.
Tēnā koutou. My name is Amy Barron. I've prepared supplementary planning evidence on behalf of Hokonui-Runanga on the SASM/Ngāi Tahu Cultural Values chapter of the proposed district plan. Just as a quick background, I previously prepared planning evidence that was presented at the opening hearing for the chapter, and that was on the 5th of December 2024. At the opening hearing, there were several questions and some additional work was put forward by the panel. So as a result, my supplementary evidence is largely focused on responding to the feedback that was received from the panel at the opening hearing, with responses also provided in relation to evidence that was made by other submitters on the chapter. So in terms of my responses to the panel's feedback, in my evidence, these include the types of provisions that I consider are anticipated in the Mana Whenua chapter, and that's based on my taking direction from the National Planning Standards, which had led me to conclude that I do not support combining the Ngāi Tahu Cultural Values chapter with the Mana Whenua chapter, and as a direct output to this work and as a potential option to clearly distinguish between the two chapters, I've put forward the option of locating all of the overarching Ngāi Tahu cultural values, objectives, policies and methods into the Ngāi Tahu cultural values chapter, while retaining all of the relevant content in the Mana Whenua chapter, with the intention that that content would provide context to support the Ngāi Tahu cultural values related provisions. So as noted in my evidence, I acknowledge that this option would require further revision work to both chapters, and I've appended the proposed revisions for both chapters, which are located in Appendix D, which is the revised Mana Whenua chapter, as well as Appendix H, which is the Ngāi Tahu cultural values chapter, and I've also included supporting analysis of changes to the provisions, so that's the objectives, policies and methods, which is provided in Appendix B. I think, one thing to clarify is, so in my evidence, I'll just find where it was. So when I was talking about going through the Mana Whenua chapter, so that's at paragraph 16, I had mentioned that the output was in Appendix B. But that's also, should it say, Appendix H, which is the Ngāi Tahu Cultural Values chapter, and Appendix D, which is the Mana Whenua chapter. So I also acknowledge that in making amendments to the Mana Whenua chapter, I did not provide clarification on the changes that I've made to the values which are contained in section MW 2.3. And I am happy to provide more information as requested by the Section 42 reporting officer to help inform her recommendation. But just as a brief sort of overview, I can say that it stems from questions that came up at the last hearing in December, and that was regarding exploring the option of having an exhaustive list of relevant values just within the context of the district plan or the proposed district plan, with the acknowledgement that Mana Whenua will hold other values. So that was part of the reasoning behind making those changes, and it also comes from discussions that happened at the Hearing Stream 3 hearing. So that was for the Mana Whenua chapter, where there was discussion around the use of the term wahi tapu, and how that could come through into the plan. And I think at that discussion, or as part of that discussion, the suggested way forward was to provide guidance in the Mana Whenua chapter, so instead of having a definition, and that was because the term wasn't referenced in a rule, so there was no requirement to then define it under the National Planning Standards. And further, the revised values were also informed by the discussions that I had with Hukanui Runanga when we were undertaking the refinement exercise for the Ngāi Tahu Cultural Values Matters of Discretion or Control. And so when we were doing that exercise, the values that were sort of articulated when we were going through those matters of discretion are representative of what's now being put into this chapter. So yeah, that was another element that came through, or was sort of, I suppose, the background context to why those changes were made. Yeah, as a follow-on and based on my view that the Ngāi Tahu Cultural Values chapter needs to remain separate from the Mana Whenua chapter, I've outlined options on where the standalone chapter could sit in the proposed plan, and that is again taking direction from the National Planning Standards. And so the options that I've outlined include locating the chapter under the Historical and Cultural Values heading as an other cultural values chapter, or under the Strategic Direction heading in its own separate chapter, so that would sit separate to the notified UFD chapter. And it would be on the basis that it's a specific strategic direction matter, which under the National Planning Standards then requires that it sits in its own chapter. And I note that both potential options in terms of location of the chapter within the plan are within Part 2 of the plan. So I've also covered off my position on including methods as a provision type in the proposed plan. And this is set out at paragraph 22 through to 27 of my evidence. And just as a summary, my position hasn't changed. I still support the inclusion of methods in the Ngāi Tahu Cultural Values chapter, and some of the reasons that I've set out in those paragraphs includes that I consider that the methods directly support the implementation of the policies, but just in a more user-friendly and clear way. And while I acknowledge that methods hold limited weight compared to a policy, for example, I think their inclusion provides certainty to plan users that the work set out under them will be undertaken. And it also responds to confusion and uncertainty that has come through in submissions made on the chapter. So yeah, it just gives more clear guidance to plan users that there will be this work undertaken that will enable this implementation of this Ngāi Tahu Cultural Values approach. I've also gone through the accidental discovery protocol. So that was something that came up in the December hearing around there being potentially a number of different protocols referenced in the plan. So I think it's already been mentioned that there's an existing ADP in the Earthworks chapter, I think it's Standard 7, and in that existing ADP it already cross-references back to MW 4.1. So as a logical way forward, and after getting the okay from Hukanui Runanga, we agreed that it could be just a lot more user-friendly to have all of the content in that one ADP rather than having a plan user then have to go back to the Mana Whenua section to then read that part of the ADP, just have it in one place. I've also gone through other minor amendments to the Mana Whenua chapter, so that's in terms of the content. I think there was some still outstanding concerns around use of some of the language in the chapter, so sort of more first person type wording, and just, yeah, again, like I said, clarifying the values that are specified in MW 2.3, and sort of specifying that within the context of the proposed plans, these are the values that Mana Whenua wish to consider or have considered. And I've also provided a detailed analysis of the Ngāi Tahu Cultural Values related provisions. So those are the ones that sit throughout the plan, and that was a follow-on from the high-level gap analysis table that was produced as part of the further response to Minute 15 that went out, I think it was end of December. So yeah, this further work was undertaken by Hukanui Runanga and myself, and it sought to just better understand the provisions that exist within the notified plan, and sort of how they all actually interact. So it's really just trying to understand what are the linkages between these different provisions. So that goes through from objectives through to policies, through to rules, just to understand how well integrated the Ngāi Tahu cultural values approach has come through into the relevant chapters of the plan. And then have been able to undertake that exercise, then having the ability to determine where there could be gaps in those provisions or other issues that might be related to those gaps. So, yeah, as part of the further work, consideration was also given to having a think about whether the overarching provisions that sit within the Ngāi Tahu cultural values chapter alone can be relied on to fill these potential gaps. And just as a bit of a key outcome to that detailed analysis, and I know it's already sort of been talked about a wee bit earlier today, but yeah, there's an inconsistent approach that has been taken to integrating Ngāi Tahu cultural values related provisions throughout the plan. And this was something that was also identified as part of that initial gap analysis work. And I think because that came through in that work, that sort of triggered the thinking that we need to go further to understand what extent this inconsistent approach that has come through, you know, how far does it actually go? But I guess, yeah, by doing this additional detailed analysis work, it's really helped us understand the extent and the complexity of the issue, which, yeah, wouldn't have been possible if we hadn't have done this work. And as mentioned earlier, there's around a 50-50 split between chapters where there's very much a clear integration. So that would be your objectives through to your policies, through to your rules. And then there's the other 50% where there might be an objective, no policy, maybe a rule, or just a rule on its own. So there's, yeah, varying levels in some of those other chapters. And yeah, the split that I've found is listed at paragraphs 38 through to 39 of my evidence. And then at paragraph 40 to 41, this is where I've talked about the ability to rely entirely on the overarching provisions in the Ngāi Tahu cultural values chapter to fill those gaps. And yeah, I think from my perspective, because these overarching provisions are high level in nature, I would have concerns about relying on those provisions, just because they can't provide the same level of specificity that you would find in specific chapters of the plan. And yeah, and to demonstrate my concern, I did include an example scenario which is set out under paragraph 41, I think it is. And yeah, I also raised a query as part of that sort of discussion or consideration about whether the intent was that these overarching Ngāi Tahu cultural values provisions would have some sort of primacy over other provisions. So if there was a gap, it is the expectation that they then have more weight to address that gap. But if that is the case, I sort of have raised concerns about that too, because I wasn't aware that there was a hierarchical approach that was being taken in the proposed district plan. And two, if there are gaps that remain unfilled, I'm just sort of conscious of the submissions that Hukanui Runanga have put in around wanting to add more specificity in terms of what their values and concerns are, and how that could undermine what's been sought through those submissions. My recommendation from this detailed analysis work is to have a consistent approach throughout the plan chapters by integrating a range of Ngāi Tahu cultural values provisions in all relevant chapters that are clearly connected and provide sufficient detail to plan users so that relevant values can be clearly identified where a consent is required. I consider this approach would remove confusion and support consistent administration of the Ngāi Tahu cultural values approach while addressing submissions that have been made by Hokanui-Rurunanga on this very matter. Under the refined relief heading, which is at paragraph 50, I envision that would be part of this broader plan-wide work stream that I consider needs to be carried out, and I have put in there by Council's 42A planning officer or a lead planner alongside Hokanui-Rurunanga and Hokanui-Rurunanga expert planners to really go through and do that forensic examination that was mentioned earlier this morning. So if there are revisions and that need to be made in those chapters, we can have that ability to look at it. Refinement of rules and standards, so that's the Appendix G that's been talked about a bit already. So this additional work stemmed from the concerns that were raised by Hokanui-Rurunanga as well as submitters around the uncertainty of Ngāi Tahu cultural values and the amount of rules that these values had matters of discretion attached to. And so, yeah, this work consisted of Hokanui-Rurunanga and I going through each of the matters of discretion and just really talking through what the concerns were in relation to those matters. And then from that being able to, where sort of appropriate, refine some of those matters of discretion. So yeah, paragraph 46 provides an overview of the key outcomes that came out of that exercise. And then at paragraph 50B, which is sort of going back a wee bit, this is also part of that broader work stream, going through and making the changes to the rules as a result of that refinement work. So other issues with the PDP provisions I've also gone through, and that's sort of more your discrete matters. So that's sort of use of some of the different terminology. I think one of them was the term cultural activities, which came through in several zone chapters. So yeah, there were references and objectives and policies, but there were no clearly related rules, and that was because there's no definition of that activity. But I do see that Ms Bennett has picked that up in her response, which was helpful to sort of clarify that her thinking was it Māori customary activities? That was the intention, that's what it should have been, rather than this cultural activities, and there is a definition for that. And so, yeah, I've had a look at the definition, which was also helpfully included in Ms Bennett's response. And I guess I've gone through the rules, and one of the chapters where this cultural activities comes through, just to try and understand, do the activity rules align with the definition of this customary Māori activities? And I think there is some alignment, but yeah, I guess that's sort of, that's an issue there where it'd be helpful to have that time to forensically go through with Section 42A reporting officer to understand how well aligned are these provisions in terms of your policies through to your rules, because that's just a clear example there where I didn't understand what it was trying to enable, and then when you look to the rules, it has a whole bunch of different activities, none specifically, a Māori cultural, no it's not, is it Māori customary activity? So yeah, just really trying to understand it, because the example that I looked at was the NOSZ chapter, and so it has community facilities, which I thought maybe that it could fit in there. Sports and recreation activities, yep, it seemed like it was quite well fit there. Conservation activities, park management, maybe not. Agricultural, horticulture activities, pastoral activities, maybe. Visitor accommodation, wasn't so sure. So, I mean, yeah, these are just some of the issues that I'm highlighting, because I think when it gets to the actual implementation of the plan, these will be things that come up.
So
yeah.
just to check, so when we were talking to Ms Bennett this morning, this was one of those things that was going to be nailed potentially in the wrap-up hearing. So am I picking up from you at the moment, there's still a bit more work to do to respond to that Yeah, and so the signal that we've got is that's the kind of thing that is destined for the wrap-up hearing, so that provides maybe a bit of extra time to
Yeah,
deal with that issue.
if it's possible, I think it needs to be covered off. And yeah, one of the other issues that I had identified was potentially some missing rules as well, and that was in relation to the transport chapter, earthworks, and the NOSZ chapter. And I do note at paragraph 36, Miss Bennett explains that she's checked these chapters with the authors, or checked through the sort of issues I've raised in relation to those chapters with the authors of the chapter, and they don't share the concerns that I've raised, but I wasn't really sure why, because there wasn't actually an explanation given.
The way I understood their response was that there might be a permitted activity rule in the left-hand column or the middle column, and the right-hand column says the activity where compliance is not achieved, non-complying. So it doesn't need a separate rule because it's deemed to be made non-complying by the fact that it's non-compliance.
Yeah, but then I suppose then that sort of raises the other question is why do you have these matters of discretion if there's no rule that goes back to them? Because it's non-compliant, you can consider anything, and maybe you would.
Yeah,
but
and there is an issue with the plan in that sometimes the status of where the conditions aren't met does, for example, in one of them it says you must comply with standards X, Y and Z. And in the right-hand column, if you don't comply, it's a discretionary activity.
Yeah,
You go to the standards themselves,
it's different.
and it says
yeah.
if you don't comply, it's restricted discretionary. So there's a mismatch that will be directing, if it's not on the list, that actually be tidied up in terms of the technique that's used.
Yeah.
And the easy way out of it is that if there is a rule that says you must comply with the standards as part of the permitted activity status, then a subparagraph on the right-hand side in referring to those should be, it is the status of what appears in the standard if you don't comply.
Yeah.
So refer to standard X to
Okay.
play. But in other cases, it may sign if you don't comply with condition number 1, you're discretionary. If you don't comply with condition number 2, which is the standards, see standards.
Yeah, okay. Thank you. That does make more sense.
You're not the only one who's brought those issues to our attention. It's confused a lot of people in this process, yeah.
Cool. Yeah, I think that pretty much wraps up most. And I've also done responses to some of the submitters' evidence, but yeah, I might just move to questions now.
Well, probably first up, in terms of your Appendix G, having a look at it, a lot of what you've got here in the pink or the brownie, whatever, for example, it says removed matter of discretion 7. That's easy to understand. It's been suggested that because you haven't got the full rule there showing cross out, etc., that it's a bit hard to follow. I went through and actually compared the rules in my copy of the plan to having this open, and I had no problems following it. But I can see that some people would rather have the full rule with cross out and underline shown in it. And it's not all of them. There's only a small number in your table where I believe that needs to be done. How long will it take you to do it?
If I could get access to a document where I can just go through without having to, I guess, manually try and pull off all the different rules from, because there's a PDF version of the plan, but that's the notified plan. So if I could get the latest. Yeah, I mean, I'd be happy to do that if I could get
We
access.
had this discussion briefly in the break, and I did offer to assist because the trouble for Ms Bieran is she's working off that PDF document, and probably the council team has more access to a couple of the chapters which are slightly more complex, so we've offered to assist with that. So I don't know if that assists.
So how much time is needed? If we were to say, give us an updated version of this that shows the crossouts are the ones where it's needed, how long we're looking at.
Can we talk about that as a part of the procedural directions arising at the end? Because I think it also, you've also got another direction that you're making for fed farmers, so we can loop it all in terms of timeframes at the end of this hearing, or at the appropriate time during this hearing.
This is the preliminary set of asking fed farmers to look at something. So, okay, we'll circle back to it.
Thank you.
Right, I'll give you more time to think about it. Yes. So, can I turn to your appendix, one that's got the colours in it. It's Appendix B. And I know it's repeated elsewhere, but this is the one I've drawn comments on. And one of the issues that we've been exploring today is to what degree can we integrate what is in Ngāi Tahu Cultural Values Policy 1 into the relevant sections of the plan. And do you see some benefit in doing that?
Yeah, so in terms of that policy, I think the intention was that it would sort of provide a bit of a signpost that these are these sorts of activities that are located within these specific chapters, and then on top of that policy, you would then have that very clear direction as well in those chapters. So that was sort of my thinking of how it would actually work. So it would be sort of twofold. It wouldn't just be at that, I suppose, overarching provision level. You'd also have that guidance in the specific chapter too.
Okay, so if it was in the specific chapter, it probably points to doesn't need to be a policy in this section, as long as it's recorded in some way.
I think if it's recorded in some way, it might still be quite helpful because if you are picking up the plan and you're starting at the sort of beginning of the plan and working your way through, it might be good to have maybe a table, which I know has been included in the notified plan, where it sort of says these are all of the relevant chapters that this chapter relates to. So we could do that as well and make sure every chapter that these overarching provisions relate to are listed there too.
Well, looking at your evidence, it's every chapter you're asking, in effect.
Basically every chapter, yeah. But I mean,
so and what it points to is in how the plan works actually needs something added to it as well.
I think so. I think just to provide that sort of logical flow.
Can I go back to one that I asked this morning about buildings and structures B? So what is the concern about buildings and structures exceeding the permitted height?
Yeah, so when I talked to Hokanui Runanga representatives, it was having that ability to connect with significant features, so natural features, and I suppose when we were discussing it, I was thinking about, well, we know in some areas within the district there isn't that ability to really to view some of those significant landscapes or features. So it was sort of we can do some refining to those built height exceedances in areas where maybe we don't think there is such a view, or it's going to be an area where more intensification, more sort of building coverage is expected. So it was sort of trying to find a compromise to allow for where there are areas that have sort of large open spaces and lower built form anticipated, where you do have those viewing opportunities to sort of protect it as possible.
So anywhere on a public road, you want the ability to retain a view, for example, of the Hokanuis.
I think from your publicly viewable spaces.
And so if we use the model of Auckland, where there are protective view shafts of the volcanoes around Auckland, and we haven't adopted that approach here, and bearing in mind that you could put up a shelter belt that blocks those views anyway, what is there to be gained by that provision?
And I guess it kind of does go back to what Ms Bennett was saying this morning too, where it's not necessarily going to say you can't do that, but then it might just allow for consideration into the design of the... So if you are going to be exceeding the height, it gives that opportunity for, I suppose, Hokanui Runanga to put their perspective across and maybe find some other way that forward, but another thing that did come up as well when I was going through this refinement exercise with Hukanui-Runanga is that their marae is, they need to move. And I suppose that's something that's in their mind as well, is wherever they move, they would like to have that connection, and that's probably going to be in a rural zone as well.
Yeah, so it came up in the discussion we had for McNab in terms of the Maori purpose zone there, and what was the need to protect view shafts from that. And the response was that it is going up so high that it wasn't an issue, was my recollection. But the case law is clear. There is no right of protection to a view unless a particular view, something like a view shaft, is specified in the plan. And it may be a legal issue that needs to be responded to rather than that. Okay, C talks about buildings and land activities that breach servicing standards. Well, I don't think we have servicing standards as such. Are you talking about that where there's intense development on the site, there's a potential concern, and it happened with the retirement village in Reeve Road, where they started clearing the ground. There was a heavy downpour. They'd put in a temporary water storage dam. It wasn't enough, and it flowed into the adjoining property and down an adjoining creek. But that was something that maybe could have been dealt with as part of a subdivision consent and overland flows, which we're talking about in 2 weeks' time. What is the issue there?
Yeah, so I think in a couple of the zone chapters there is a particular servicing standard, and that's in relation to on-site servicing, so that's for wastewater as well as stormwater treatment and disposal. So that's more the design and I think capacity to connect to existing servicing that's available within that zone. And if that can't happen, then there's alternative options. But yeah, so under that standard, it's first option is you connect into a reticulated system. If you can't do that, then there's some alternative options that are set out. And if you can't do those options, then you can't comply with that standard, and then you need to look at what those other alternatives are.
Okay, what's the example of the rule you've got? Because my recollection, it gave you the options of if you can't connect to the council system, you shall provide on-site servicing.
Yeah, so there's two. So there's the LLRZ S2 and GRZ S2. Just make sure that's one. Oh, and there's, no, that's it. Yep, sorry.
Okay. It's I raised this morning as well, that was the earthworks one. G talks about works undertaken near the river, significant natural features or archaeological sites or not otherwise anticipated infrastructure. Two things arise from that. The archaeological sites are shown as a information layer. So it's the implication of what you are wanting is that you're actually turning that layer into a rule.
I'll just make sure I'm looking at the right. Is this under the
G.
G under policy 1?
Yes.
Yeah. Yeah, so I think this was, there's a rule in the infrastructure chapter. So this is basically trying to summarise that rule within this policy. And these were sort of the parameters that were set around whether you could actually do it as a permitted activity or not. And if you do, if there are any of these matters, so like breaching the required standards, new infrastructure near the Mataura River, these all trigger the need for consent. So that was sort of what G was trying to do, was
Yeah,
respond to
but
that.
the reference to archaeological site, they are an information layer, they are not,
Or is it Schedule 3 archaeological sites? So there's the schedule. There's, like there's the map layer, but there's the schedule. HH Schedule 3.
the recommendation is that schedule comes out.
Look at the rule.
And so that's part of the decision making.
Yeah,
Yeah.
yeah, okay. And the recommendation was it comes out and sits as it is at present as an information layer. And not otherwise anticipated infrastructure, what does that mean?
So I think that was sort of trying to bring in activities that aren't otherwise, anticipated within the zone, so they're not necessarily provided directly as a permitted activity, but they would be a discretionary activity.
So if it's a non-complying activity or discretionary activity, the policy framework that's generally there applies anyway, which is generic in terms of Ngāi Tahu values as well, isn't it?
For that chapter it is, and I think
Yes.
that's why we need to have this forensic approach to really make sure that all of the provisions are correctly talking to each other.
Now, you use the phrase a lot, works within, works associated. How is works the correct word, or is it activities?
It could be activities.
But I would have thought there's cases where earthworks or something.
So I think earthworks I've dealt with separately.
Okay.
Yep.
So where it reads works, we really should be looking at activities.
Yep.
Why is subdivision within the development areas a matter that is of potential concern?
Where's the subdivision within, is that N?
Yeah.
Specified areas. Not otherwise provided for. Yeah, so at the moment they are, there's already, so it's a restricted discretionary activity automatically, and then there is that matter of discretion in relation to, at least within the specified development areas. So I think when we went through the rule refinement, there was a preference to keep that matter of discretion with that one, and that was more around the whole. And I guess that's kind of where it can get a bit confusing, because the servicing of those new areas was something that had come up as well. So when you're at that subdivision stage, having that ability to understand in those development areas what that was going to look like, and maybe have an opportunity to be involved in that work as well.
Okay. Both objective 1, I'm not too sure if it's a page forward or a page back, depending on which way you hold the staples on these things. Ngāi Tahu Cultural Values Objective 1 and Objective 2 both refer to decision making. I posed the question this morning that it's really resource consenting or resource management processes, because as it's worded, it would imply that Ngāi Tahu are the decision makers.
Yeah, and that definitely wasn't the intention. I guess I'm pretty sure there was some discussion, was it from Transpower, around if it was decision making that could allow for not just resource consenting as well to come in to the picture.
That was me asking them if that term would assist, and now I'm thinking the phrase we might need is resource management decision-making processes, and that would pick up resource consents and designation. So it was me who introduced that into the mix, and probably confused matters, but I think this exchange has drawn that out, and we need something that isn't limiting itself to resource consents, because it's not the only thing that's going to come along. Yeah.
and actually that is in the proposed NTCV02, Resource Management Decision Making.
Okay, I'll let someone else while I catch up on the rest of my notes. Glenys.
Question. In terms of scope, would it be correct that Ms Brand's evidence in hearing stream 3 allows us to bring the activities into this section?
It's a legal question.
Sorry, I don't quite follow your question.
There's new activities brought into Ngāi Tahu cultural values.
Mm.
Does Ms Brand's evidence in hearing stream 3 allow us to bring those activities into the plan, and it's not going to be a scope issue?
Yeah, that the evidence helps. I mean, it helps track the changes and and help give context to where we've got to. But to get the actual scope, I would my recommendation would be go back to the notified version and the Ngāi Tahu submission rather than the evidence. I think that's the neatest way to get the scope. The evidence in hearing stream 3 is really important to give you the evidential basis you need to make your decisions, and then the scope comes rather more from the notified version for the actual legal scope.
I just want to clarify again, I know I've probably said this multiple times today, but I did notice in some of what came through from Federated Farmers Legal Counsel was focused on the scope of the Hokanui Runanga submission. And in my exchange there, I was wanting to be clear that for us on the panel, it will be all submissions that provide the scope. So yes, we can look at the Hokanui Runanga submission for the scope of what was being sought, but then that's going to butt up against other submissions, and Ms Chadwick has pointed us towards the Southern District Council submission as one. And so then it becomes pertinent to Ms Beerin's evidence around her response, that what she's doing in providing us with material is responding to questions that we have raised and a response to submitters and other submissions. So I think we can't lose sight like that the Hokanui Runanga submission is providing some important scope, but not the only scope.
You know, that's a really helpful clarification, and I agree, and I think probably the evidence is Ms Beerin's evidence is the conduit or the connection that we say justifies the relief that can come from any of the scope can come from any of the submissions, and Hokanui Runanga is one end of the spectrum, and there'll be some other submissions from landowners and things at the other end. Yeah.
Well, in terms of this chapter, the scope is between the notified version, complete withdrawal, amendment, and everything in between. So
Broad.
yeah.
Cliff, you got Maria? No, I haven't finished, but I'm having a break.
Okay. All right. So my usual approach, starting at the top. Paragraph 12. It does go to some of the exchange you were just having around MWP1. So what we've got in evidence from Ms McLeod and Ms Bennett is, there's an opportunity to revisit what's sitting in policy and what's sitting in explanatory text. And because we've heard from Transpower why they've got particular concerns around this policy, that perhaps I didn't appreciate until we'd had that exchange, which is often the case. And the good thing about having a hearing, so you can tease these things out, is that, that how critical it is for them to have objectives and policies that make sense when they move into the designation process. And so she was putting to us that the policy could complicate that process because the policy would then in that process get divorced from the rules and matters of discretion and things like that it's drawing from, and then it's just sort of standing by itself and then trying to make sense of the policy in relation to other things like the NACETA and what have you. So so then one thing we explored with you and with Ms Bennett is how, and Ms Chabot actually, how if we did think that we might need to go back to a slimline version of the policy, which is where things began, understanding the purpose of going down this exercise, which was still important in terms of what it's drawn out, was a desire to signpost, that, which is what you were saying, that desire to signpost, that some of the signposting could potentially sit in explanatory text with a slimmed down policy. So previously we had a slimmed down policy that didn't have a signpost with it. Now we've got a policy that's got all that sitting in it, but we've got queries being raised around what impact that might have in different scenarios. So that being one from Transpower saying, well, on the one hand they're saying this could be really hard to apply if we're moving into a situation where it's divorced from the rules in the plan. And then the other thing that she was saying was that if it is sitting alongside other policies and other chapters that are addressing those matters, it's not adding anything. So she was sort of saying it's problematic when it's divorced from the rules, when we try and apply it in a designation process, and if it stays in a resource management, resource consent process, it's not adding anything on top of the others. And that comes back to the purpose point that you were saying, which is its purpose was to provide a signpost to give people a sense really early in the plan where you might encounter this. So could we, how would you look at that idea of maybe slicing and dicing it again so that all of that material isn't lost but is maybe in explanatory text with a slim down, back to a slim down policy?
So potentially it would still be a policy, or yeah. But then could also maybe just be more explanatory text. So would you be exploring both?
Yeah, so we started with fully explanatory text, with a policy that was causing issues because it said high risk activities and no one understood what that was. Yep. And then there was a desire to illuminate what that meant because the term was problematic and people didn't know what it was trying to say.
Yep. And
then through all the evidence that we've got, the clear message is it was all those activities that have the potential to impact on Ngāi Tahu values to an extent that they require further examination. All of that's covered in those triggers and matters for discretion. So understanding that, that's what we're responding to. If we went back to policy, I'll just read out what I'd scribbled down, and we don't have to stick with this, but it's just to help you understand what I'm thinking. So for instance, this was my for instance, the effects on relevant Ngāi Tahu cultural values are considered when making decisions in resource consent processes, where I guess we would have to say resource consents or designations are required for activities that have potential to impact on those values. And then you could go through matters of control, matters restricted for discretion, however we're doing it in the plan.
Yep.
Something like that. But I guess the point of it then is that it's saying this is how this plan is dealing with effects on these matters. And I think that's actually what we've unearthed during all of this, this is what the plan is doing, this is how it's delivering management of effects on cultural values. And so the other thing that you might have, whatever. But anyway, so the idea would be that you'd have a slimmed down policy that's telling you how the plan is expecting this to happen. And then all of those listed things that have come out of the rules and all that work that both you and Ms Bennett have done could be captured in explanatory text, which is like highlighting, this policy has its life in these parts of the plan.
Okay.
So it's a combo.
So it could, be both.
Yeah.
Okay. Yep, I'd be happy to go back and have a look at that.
That's a matter we need to have a talk about.
Okay.
Give some direction.
Yep.
That's the point we've reached.
Okay.
It's more to just get a sense that you weren't wedded to any, that you would be favourable to going down that line. Yep.
Yep.
And I thought it was very useful at your paragraph 12, which is related to the discussion. I feel it's related to the discussion we just had. I thought it was really useful at your paragraph 12 that you'd burrowed down into what process-related or context-related provisions might mean. That's really helpful to us. I also think it's really helpful that you did an analysis of other plans to say, well, these other mana whenua chapters around the place don't have anything other than explanatory text in them. But obviously the national planning standards based on your analysis in paragraph 12 don't prevent us from incorporating them. So when we spoke to Ms Chadwick, she was, oh no, that's a bit later on. No, that'll do. So you're giving us a clear view that you've got a preference to stick with the norm and not have anything other than explanatory text in there. But you would also accept that it's available to us because of that. Yeah.
Yep. Yes.
I do note, however, that when you're looking at the other district plans, you made reference to Selwyn and the approach they've used, but they did not have a urban form development chapter, they just had an urban form chapter. So they didn't have development included in it, which meant the relevance of that to your point you were making, I didn't see is actually applied. And with the other ones, there is SASM chapters in those other plans, but we're in a different situation here, and I think it is going to be a different answer that we come up with compared to the other councils. So while it's useful to know what the other councils are doing, we're using a different approach, and our answer at the end of the day is going to be different.
So the other thing that's happened when we've explored this with some of the other parties, Ms Scott, when we were talking to Transpower, was emphasising that we need to take some care around what we put in explanatory text and what we keep in the provisions that have legal weighting. Yeah, so I think that bit there, if say we've got a process-related provision that's drafted that would have legal weighting, it's not explanatory text, but we would look at it and go, that looks like process. So step one is, do we need this thing to have legal weighting? Yes, no. is this thing process related? Yes, no, like that. So if we get a yes, this is process related, would you accept that that would be when we would logically hoof it into the mana whenua chapter?
I think, yeah, it could go in the mana whenua chapter. I guess I'm just conscious of having different provisions scattered throughout different chapters in the plan, and then how they all, I suppose, work in with each other. And that was sort of a concern that I sort of had when I was looking through the national planning standards and sort of getting to this position where I think it would be good to just sort of keep the explanatory content in the mana whenua chapter, and then have your provisions that are supported by that content follow through. But I do take the point that there is that ability to put process-related provisions in the mana whenua chapter. I guess I just would have to think about it, how it would all actually work together.
That's helpful to have your thoughts around being worried about scattered provisions. And the other thing that I guess I've got on my mind is that if we did see something that it had passed the yes, this should have legal weighting test, rather than explanatory text, and then we go, is it process or is it managing effects? If we say it's process related and then we need to put it over there, we can't have hanging provisions, i.e. if that provision was a policy, it can't just be a policy that hoofs over to the MW chapter. It needs to be underneath an objective.
Yeah.
You know, it can't just, it's most likely to be a policy or a method where you can't have an orphan, which is, I guess, what you're, is that kind of...
Well, that's kind of what I'm worried about.
Yeah, you don't want orphans.